Ranjan Gogoi, the former Chief Justice of India, in his maiden speech in the Rajya Sabha, called the basic structure doctrine as debatable. While there has been much ado about his statement, we must ask ourselves, is he wrong? Aren't most things regarding the law up for debate? It is possible, perhaps, that the media had an issue with not what was said, but who said it. Anyways, I thought the basic structure doctrine would be a topical subject for this episode. There is an understanding currently that the central legislature has the ability to amend any part of the constitution, including the fundamental rights, but without affecting the basic structure of the constitution. What exactly is the basic structure? That we do not know, as the judiciary has not defined it yet. That said, is Ranjan Gogoi wrong? If something is officially undefined, is it not up for debate? So, we do not have a definition, but we do have a plethora of judgments, and from these, we can get an idea of what parts of the Constitution the judiciary considers sacrosanct and a part of the basic structure of the Constitution. Here is a list: supremacy of the Constitution, sovereign, democratic, and republican nature of the Indian polity, secular and federal character of the Constitution, unity and integrity of the nation, socio-economic justice, rule of law, parliamentary system of government, freedom and dignity of the individual, balance between fundamental rights and directive principles, principle of equality and the principles underlying the fundamental rights, separation of powers between the three bodies, judicial review, free and fair elections, independent judiciary, effective access to justice, limited power of Parliament to amend the Constitution, powers of the Supreme Court under the Articles 32, 136, 141, and 142, powers of the High Courts under the Articles 226 and 227. Now, let's look at the evolution of the basic structure doctrine. The two articles most pertinent to the topic of the basic structure doctrine would be Article 13 and Article 368. Article 13 voided any and all laws that were inconsistent with the provision of Part 3 of the Constitution, that is, the fundamental rights. Article 368, on the other hand, gave Parliament the ability to amend any provision of the Constitution in accordance with the procedure laid in this same article. The question whether fundamental rights can be amended by the Parliament under Article 368 came for consideration of the Supreme Court within a year of the Constitution coming into force. The First Amendment Act of 1951, which curtailed the right to property, was challenged in the Shankari Prasad case of 1951. In that case, the Supreme Court ruled that the power to amend the Constitution under Article 368 also includes the power to amend fundamental rights. In 1967 Golaknath case, the Supreme Court reversed its earlier stand. In this case, the constitutional validity of the 17th Amendment Act of 1964 was challenged. The court held the 17th Amendment invalid. While the court in 1951 stated that an amendment was not a law, in 1967 the court was of the opinion that amendments too are laws. And since Article 13 protects the fundamental rights from laws of government, Article 13 holds strong against amendments under Article 368 as well. The Parliament's reply to the Supreme Court judgment was to enact the 24th Amendment Act in 1976. Article 13 and 368 were amended, taking amendments out of the ambit of Article 13 and giving Parliament the power to abridge or take away any of the fundamental rights. The third case in the series saw the first mention of basic structure, that is, the Keshavananda Bharati case of 1973. Given the 24th Amendment, the Supreme Court overruled the judgment in the Golaknath case and backed the Parliament by asserting that the Parliament did indeed have the ability to abridge or take away any fundamental right. However, there was a caveat. The Supreme Court laid down the doctrine of basic structure of the Constitution. The Supreme Court did not allow the Parliament unconditional amending powers. It held that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. This doctrine was affirmed in the Indira Nehru Gandhi case of 1975. Again, the Parliament reacted to the judiciary by enacting the 42nd Amendment Act of 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of Parliament and no amendment can be questioned in any court or any ground, including the safeguards of Article 13. In 1980, in the Minerva Mills case, the Supreme Court invalidated this provision of the 42nd Amendment. It argued that the Parliament was using its limited amending powers to give itself absolute power over the Constitution. Put simply, it's like asking a genie for 100 wishes when you have been offered one. The Supreme Court adhered to the basic structure doctrine once again in the Vaman Rao case of 1981 and has since done so on a number of occasions. While we cannot know what the future may hold for our Constitution, it is important for us to keep an eye on the past. The framers of the Constitution did not want a static document, they wanted a living, breathing Constitution. The Constitution came with procedures for its own evolution, but evolution must be for the better. The parliaments of the present and future must refrain from changing too much too fast for flawed reasons.